the practice and types of matters that you handle in Haller and Sage?
Sure. Good morning, Nancy. So I handle really a wide variety of commercial litigation matters, everything from breach of contract cases to fraud claims involving businesses and sometimes individuals. I also do a lot of commercial foreclosure work and litigated residential foreclosure work, meaning that I don't necessarily handle ordinary foreclosure cases, but I do handle them when they become litigated for some reason and go to trial, or sort of complex discovery issues in a lot of cases. That's a big part of my practice, is that foreclosure work. And I also handle bank work, financial institution work in general, defending banks from claims from sometimes other banks and often consumers in the state and federal courts in Connecticut.
What do you find most interesting about providing legal counsel to banks and financial institutions?
Well, I find it fascinating for a lot of reasons, and I think a lot of people don't really understand the sort of world in which I live. But the diversity of claims that I confront, these span everything from contract law to tort law. There's often sort of personal injury elements to it, emotional distress claims. It really runs the gamut of a lot of different types of law in these cases. Sometimes even family law sort of creeps into some of these cases. So that gives me the opportunity to be exposed to a lot of different practice areas that I otherwise wouldn't be exposed to. And the other thing that I find really interesting is, most of my cases end up going to trial or pretty close to trial. So they're usually pretty intensely litigated, and I've been very fortunate to develop a lot of experience in the courtroom that I might not otherwise have developed in other areas of law.
How do you decide when to litigate a matter rather than resolving it by other means, such as arbitration or mediation?
So by the nature of a lot of the work I do, particularly with the residential foreclosure cases, it's often not my choice. By the time the cases come to me, the ship has often sailed, so to speak, on whether the case can be resolved or not at that point in time. Usually those efforts have failed. Having said that, there are occasions where, I almost always recommend to clients that cases be resolved if it's even remotely possible, rather than litigated. I have enough experience with both bench and jury trials to know that no result is ever guaranteed. So my inclination is always to try to resolve a case. But, I guess the short answer to your question is, we do an assessment of certainly the cost of litigation going forward, the risk of litigation going forward, because I don't care what anyone says, there's always risk, no matter how allegedly perfect the case may be. There's always risk of an adverse result, and we weigh that against the litigation cost going forward and obviously the likelihood of success. And obviously, there's often, other factors, business-related reasons as to why a case maybe should be resolved, even if it does have a high prospect of legal success. So there's a variety of factors that go into it. But the bottom line is we're always looking for opportunities to settle the case, either, sort of informally or through more formal routes like mediation or arbitration.